Snedden, sorry.
May it please the court. Good morning, Your Honors. My name is C.J. Snedden, and I represent the plaintiff's appellants in this case, Mr. Nguyen and others. The appellants are respectfully asking that this court reverse the decision of
The weather in Mississippi.
the weather is actually about the same as it is here right now. It's about 33 degrees.
Well, now that you've answered that question, can I ask you another one?
Yes, Your Honor.
Why should we get into all the issues the appeals court got into on this case when the Superior Court judge seems to have decided it on what appears to be a ground that's wholly supported by the record, namely that these folks never applied for these fellowships? And the advertising issue is entirely extraneous, it seems to me, to that.
Yes, Your Honor, that is, the Superior Court did reach that conclusion.
Well, that seems to me to be right. Is it wrong?
Your Honor, the appellants do believe that that decision was wrong. Based on the pleading in the complaint and taking the factual allegations as true in the complaint, the appellants have set forth a justifiable excuse for not applying for the fellowship.
You're saying it was an act of futility, aren't you?
Yes, Your Honor, we are saying
Totally
this,
subjective, isn't it?
that it's an act of
I mean,
futility.
there's nothing in the complaint to suggest there's anything to support the idea that it would be an act of futility, is there?
Your Honor, what supports the act of futility is that the appellants did not apply for the positions later on. They didn't apply for the first position because they didn't receive notice in time. The second application for the fellowships, which occurred in for the 2000, 2001, and 2001, 2002, by this point in time, Mr. Nguyen had already filed his complaint against the William Joyner Center and the University of Massachusetts. And based on the filing of the complaint, it was his reasonable belief that it was futile for him to apply for the position because he'd already filed against the university. Your Honors, based on the Court of Appeals decision, we are asking that you reverse the decision because the Court of Appeals erred in concluding that the appellants failed to state a claim under 151B because the protected class was based on political persuasion rather than national origin and age.
And on that basis, you say that although these plaintiffs were all born, their origin was really in French Indochina, that we should consider South Vietnam, not Vietnam, but South Vietnam as their point of origin, and that's different than North Vietnam? That's the basis of your claim?
Yes, Your Honor. South Vietnam was a separate and distinct country from the United Country of Vietnam until it fell to North Vietnam.
But it wasn't when these people came into being.
Your Honor, most of the appellants in this case were actually citizens of South Vietnam, and many of them actually were in re-education camps held captive by the North Vietnamese, strictly based on their South Vietnamese citizenship. Our position is that the term national origin was construed too narrowly in this case. National origin encompasses not only place of birth but also ancestry. In this case, the appellants their national origin is different from Vietnamese citizens who reside in the North.
Their ancestry is different?
A claim based on national origin can be based on place of birth as well as ancestry.
But I mean, what's different about their ancestry?
Your Honor, it is more than just the place of birth. The South Vietnamese was a separate country that was governed by separate laws and a separate government until it fell to North Vietnam.
So if some employer was hiring all different kinds of Europeans but held a sign up or put a sign in the window that said Sicilians need not apply, that would be discrimination on the basis of national origin. Yes,
Your Honor, that's our position. National origin discrimination claims can even be based on a suspected national origin. There have been cases, there was a case in the Northern District of Illinois that actually held that being considered a gypsy you could base a claim for national origin discrimination based on this complaint too. The appellant's complaint clearly states a claim for national origin and age discrimination rather than the political beliefs. In the complaint, the claims were pled in the alternative. First, there was a disparate treatment claim, and in the alternative, a disparate impact claim. We recognize that under 151B does not necessarily protect political beliefs, but it does protect against the use of a test based on political beliefs. And it creates that, our position is that...
And where in this complaint is it alleged that political, I mean, where do you get this from?
The complaint, Your Honor, is based on the fact, the complaint sets forth that the appellants were discriminated against based on their national origin of South Vietnam and being over the age of 40. The claims were pled in the alternative if, first, that they intentionally discriminated against this group, and in the alternative, that the effect of employing this ideological test based on political beliefs has the effect of discriminating against the appellants. This is similar to a situation where a standardized employment test is given. The giving of the test itself is not discriminatory, but the effect that the test has on a protected class is discriminatory. In this case, the fellowships were awarded to individuals whose political beliefs were sympathetic to the communist government. In this case, that in turn had the effect of discriminating against citizens of South Vietnamese national origin over the age of 40. Your Honors, we also maintain that the Court of Appeals erred in concluding that the appellants had failed to state a claim under 151C because the claim was barred and not within the scope of the proceedings before the Massachusetts Committee Against Discrimination.
With respect to 151C, which part of Section 2 are you seeking to come under?
Part of Section 2 with regard to 151C. We're also saying under 151C that the appellants were discriminated against based on
you weren't in an education, this program was not to get a degree, right?
Your Honor, our position on the language of 151C is that the language in 151C says a program or course of study leading to a degree. Based on the last antecedent rule, we're saying that leading to the study of a degree relates to course of study and not to program. This is a fellowship program, Your Honor, and our main basis for alleging an alternative claim under 151C is based on the position that the appellees took in this case. When documents were requested, in one set of discovery requests, the appellees refused to produce them on the grounds that these were personnel files, seeming to indicate that they were employment records. When similar records were later requested, the appellees based their refusal to produce these documents on the fact that they were educational records. And therefore, the appellants pled in the alternative that if the claim arises under, it could be considered an education claim or a employment context claim. Your Honors,
But doesn't the course of study, doesn't it have to be a course of study that leads to a degree?
Your Honor, we maintain that program or course of study leading to a degree, that leading to a degree relates to and modifies course of study.
There's no comma after program,
not
is there?
program.
There's no comma after program, is there?
No, Your Honor, there's not. Based on that, this is a fellowship program, and the appellants applied for this program. We also...
They did apply?
I'm sorry, Your Honor. They did not apply. I'm sorry, I misspoke. Your Honors,
I heard your answer to Justice Glaney, but here's the problem that I have. Let us assume that you've got a program, and let's take a much sort of easier case, which is gender discrimination. And for some, the 2,000 winners of the fellowship are announced, and they're all men. and therefore, a woman decides that she won't apply because, well, they're going to give it to the men. And she then files a complaint with the MCAD saying that I've been discriminated against on the basis of my gender. We would say, no, you've got to go ahead and apply first, don't you?
That's where we argue that the doctrine of futility excuses.
No, I understand that, but why would it apply in that situation? Because there's nothing that in none of the materials does it say only men should apply, correct? She's just looking. We don't know whether any women applied in 2000, so we don't know whether any South Vietnamese applied in 2000, correct?
Yes, Your Honor. And taking the allegations in the complaint as true and in favorable of the non-moving party, the appellant has stated that
on information and belief, or
on information and belief, and given the opportunity to pursue this claim, the appellants could be given an opportunity to perhaps evaluate.
They can point to nothing other than. So again, it's keep it as a woman. So she says on information and belief there are other women who applied, but she doesn't know of any women who applied, correct?
Yes,
She's just concluding that they gave the forced fellowships to men.
Yes, Your Honor.
So don't we have to have her apply? I understand your futility argument, but it seems to me that is a very far reach of futility, because there's really no course of conduct here that suggests that it will be futile.
The trial judge, to follow up on this line of inquiry, cited a futility case which appears to be representative of the futility theory, which is far, far different from anything you're arguing. A long history of racially discriminatory practices, and we don't have that here. And these advertisements and this release doesn't say we don't want anybody from South Vietnam to apply for this, does it? Or anybody over 40. It doesn't say that. It says, look, we got this grant, we got this program, and here we are.
No, Your Honor, it does not say that, but the appellees, in publicizing the application for the fellowships, did not follow the procedures that are designed to protect against excluding particular ages or national origins. And by not following those procedures, they did, in effect, discriminate against the individuals of
Were these
South.
procedures found?
Your Honor, the procedures are found within the guidelines of the program. They're required to consult with HR for selecting candidates. They're required to publish the information in various trade magazines, and this did not happen. It was only published in 2 Vietnamese trade magazines, and the publication...
That supports a finding of discrimination, as opposed to a finding that perhaps they should be required to re-advertise and redo these things? It's probably too late now.
Your Honor, the appellants found out 26 days, or the information was published 26 days before the deadline, and the appellant did not discover it until 2 months afterwards.
But then we had the next year and the subsequent years.
Oh.
Yes, Your Honor. At that point in time, Mr. Nguyen had already filed his complaint, and that's what he bases his futility argument.
But if he had applied, and if the University of Massachusetts had not given him a fellowship, and if he claimed that that was in retaliation for filing his complaint with MCAD, that in and of itself is a violation of the law. So to say that that's why he didn't apply in 2001, again, it's sort of begging the question of what would have happened had he applied.
Yes, Your Honor. Again, I have to respectfully disagree and base it on the allegations that are in the complaint and on the face of the complaint. And he has demonstrated a justifiable excuse for not applying based on the doctrine of futility. The appellants in this case also argue that the proceedings were within the scope of 151C because they were in the proceedings before the MCAD. The MCAD is charged with investigating any claim that could reasonably arise out of the facts alleged. In this case, the same exact facts that are being alleged to support a 151B claim would also support a 151C claim. And in this case, Your Honors, the MCAD is charged with investigating any claim that could come with under a statute it's charged of enforcing. And in this case, it's in charge of enforcing 151C. Your Honor, it's on this grounds that that we respectfully request that you reverse the opinion of the Court of Appeals.
Thank you, Ms. Snedden. Mr. Joyce?
Thank you, Chief Justice Marshall. May it please the Court. My name is Michael Joyce. I represent the University of Massachusetts.
The trial court's decision and the appeals court decision are like two ships passing in the night. Am I right?
Well, the
trial court rested on the fact that they didn't apply, and the advertisements were basically neutral in content, non-discriminatory in content. The appeals court has gone great length on this whole national origin, all this other stuff.
there were about 10 points in my original motion to dismiss that argued that this case should be dismissed. The trial court adopted a number of those alternatives, but decided to write about the non-application.
Well, no, but she also, she did mention that she didn't think the South Vietnamese, I mean, it's somewhere towards the end of her decision, right at the end someplace, but she does, after very
She does,
careful,
but she squarely grounds it on the application point.
she does sort of, even if, which is not unusual for a
Even
superior
if,
court.
and then, of course, I think she says 151C doesn't apply for the reasons we've been talking about this morning.
Correct.
And she even added other grounds, probably in response to what you had argued, that no plaintiff other than Nguyen had even filed a complaint with the MCAD.
Right.
That's
so why
correct.
should we get involved in this big national origin conflict on a case that's extremely unlikely to repeat itself in any reasonable way? I mean, this is not like constantly occurring gender cases and racial cases and age cases. This is a very isolated case. Would you agree with me?
I would agree with you.
This program is over,
well.
isn't it?
This program continues. They continue to have fellowships.
Oh, they do.
As far as I know, it went for 3 years, and as you had pointed out earlier, there were no applicants. None of the plaintiffs applied in any of the 2 years after that. The futility argument that my sister talks about, as Justice Green has pointed out, there really has to be a showing of a pattern of discrimination known to the plaintiff. In the very first year, nothing was known to the plaintiff. He claims he didn't know about the fellowship itself. And although it was published in a press release, and that is one of the paragraphs in the complaint, a press release, and it was known for at least 26 days.
What does it mean to be published in a press release? If you only send the press release to 2 publications, what difference does it make that you call it a press release?
Well, in this case, the press release was received by the Vietnamese American community that was then passed on to plaintiff Nguyen.
I take it that the press release and the placing of the notice in the 2 publications were 2 different things. In other words, as I understood it, the University of Massachusetts sends out a press release to whomever they send out a press release, but they also affirmatively took out 2 advertisements for the fellowship from 2 Vietnamese trade publications.
That's correct.
So it's not as if those 2 publications just, I mean, when you send out a press release, you're not sure who's going to write about it.
Except you said it was targeted to the Vietnamese community. Does the record show that the press release went to the Vietnamese community?
Well, the complaint alleges that it was sent out in a press release. Page 91 of the appendix is the plaintiff's original letter to the response to the MCAD position statement, saying that he received this press release from a leader in the Vietnamese American community.
So we can infer from that that
It went to the community.
somehow it got to the community other than through these 2 trade
That's
trade
correct.
publications.
This is the Boston community we're talking about?
The Boston community. And I understand the court might not want to get involved in this national origin issue, and I'm hesitant to even discuss this at all, but I think what you see in both of the decisions by the lower court and the appeals court is a reaction to this complaint that the plaintiffs are attempting to state a claim based on political ideology discrimination, a claim that just does not exist. And the way they try to make that claim is through their disparate impact claim, saying that there was a political ideology employment test which proposed to preclude all individuals of South Vietnamese national origin over 40.
Over what?
Over 40 years old.
Oh, over 40. I thought you said over foreigners, and I couldn't.
Over 40. And that is based on a faulty premise that if there was such an employment test, that it would exclude all people from South Vietnam or with a South Vietnamese national origin. And just a base of fact, there are individuals with a national origin of South Vietnam, meaning the country known as South Vietnam for the 21 years after the Geneva Convention, that are pro-communist, and that's the basis of this entire complaint, and that's the flaw in the basis. It's a manufactured discrimination status that the plaintiffs attempt to profess here, and that's the substantive aspect. There are a number of other procedural aspects that I'm happy to speak about. The issue on 151C.
Wait, what about can you make the argument that this claim wasn't encompassed by the charges filed before the MCAD, the political creed one?
Well, the political creed is strictly in 151C. That's a 151C argument. And they make this argument by saying religion is separated by a comma from creed in 151C, and it's not defined in 151C, like it's defined in 151B. And 151B has language called religious creed, although in 151B, the paragraphs under that talk about religion and creed, and they define it as seriously held religious beliefs. And so they try to make the argument that creed is equal to the creed of communism. And my position on that is 151C does not have a private cause of action. You can't sue under just 151C in the body of that statute. You must look to 151B, just much like you must look to chapter or section 1983 for a lot of federal civil rights statutes. And so the definition of creed must be governed by the only definition that the legislature gives it in this area under 151B. And that precludes the entire expansion of creed to the creed of communism.
Don't you also, though, have problems with 151C in terms of whether these plaintiffs fit within any of its provisions substantively?
Correct. The issue that Justice Botsford brought up earlier about the issue of leading to a graduate degree, the actual language of the statute not only isn't separated by a comma, but it also talks about such discriminate or so discriminate against any student admitted to such program or course of study. The use of the word such, I would submit, specifically talks about relates back to leading to a degree. And otherwise, there would be no use for the word such in that sentence, such program or course of study. Program and course of study are synonymous here. Obviously, schools they call their programs different, and that's why I think that the legislature used this kind of language in here, but not to separate that. This chapter 151C only protects in this area for discrimination based on a program that is a graduate program, and this is a fellowship. This is not leading to a degree. And
the Superior Court judge ruled that way on that basis.
That's correct. That's correct. She did.
Mr. Joyce, with respect to the plaintiff's claim that with respect to the first, I think it's 2000 is the first academic year when they learned of it, just 26 days. The claim is that the the method of publication was designed to exclude them, correct?
Correct.
What were there any requirements as to how this fellowship should be advertised?
There were no specific requirements by the university that a fellowship should be advertised or solicited or selected in any particular way. The plaintiffs cite the Normal Employment Human Resource Manual of the university and tried to absorb a fellowship or any position that you actually compensate someone for in a stipend for the university into that HR manual. But the HR manual only says that you are supposed to follow the law. In other words, not discriminate against people and follow Chapter 151B essentially with that language.
I take it, and I haven't looked at the HR manual, I take it that implicit in that is, one, you have to, it anticipates that people would have applied for a position or sought a promotion to a position, correct?
That's correct.
I take it, though, that if there was some evidence that, that the university deliberately didn't advertise at all, maybe there would be a colorable claim. But as far as we know here, this press release just went out to all in Sunsley, right? We don't even know whether or not it went to the Vietnamese community. I mean, we know that it went to a part of the Vietnamese community, but we don't know to whom else it went, correct?
That is correct, Your Honor.
And I think it might be a violation of the law if, in fact, the press release went only to the Vietnamese community, correct? Weren't there non-Vietnamese who were entitled to apply for and, in fact, were given this fellowship?
Absolutely. There was, as alleged, a Vietnamese American under 25, someone who was born here, of Vietnamese descent, and also a Caucasian female. That's also in the complaint as well from the United States. And so I think you can infer from the complaint that it reached other people. It was not specified to one particular group or one particular age group. All age groups are actually represented in the fellowships that were awarded in the first year. I think the appeals court drew the inference that the two so-called communist recipients were also over the age of 40 and probably the similar age to the plaintiffs here. And based on the allegation that they were agents of the diaspora that was responsible for forcing the plaintiffs to leave Vietnam. And under the O'Connor case and the Knight case, as far as age discrimination goes, the plaintiff must at least express allege that the person who is hired is substantially younger than, and they don't make that claim either.
Going back to the advertising, though, I mean, in paragraphs 29 and 30 of the complaint, which we should take as true, it says that the defendant's program description, is that mean this program?
Yes.
Provided that it would be publicized in the following journals, and then it says below, also provided that certain materials would be disseminated to local and nationally Vietnamese community media. And in both paragraphs, it alleges that you failed to do any of that. Did the program material say you were going to advertise it in this way, but then fail to do it?
Well, as alleged in the complaint, Justice Cordy, it does.
Yeah,
it does say that.
Don't we take that as true?
You can take that as true, but which you have to take as true. Although
Was this a verified complaint?
this was a second amended complaint, and I wanted to bring this point up, that this was a complaint that was filed after successor counsel had been with the case about 2 years. There had been significant depositions conducted by plaintiff's counsel of the directors of the program, the people that actually designed the program and made the decisions on essentially who would receive the program, and there was interrogatories and document requests that were responded. So when this second amended complaint was drafted, there was a lot of discovery done that could have been included. And
But, well, going back to that question, you accept those paragraphs as true, but it doesn't logically follow from that as a legal conclusion, supportable legal conclusion, that violation of any advertising requirements was discriminatory.
Correct. It's the impact that you have to look at. What kind of impact does that have?
Nothing to show any adverse impact.
The only impact that the complaint offers is that the plaintiff didn't hear about the complaint.
That's right.
Or the application,
Yeah.
and the other individuals outside of Massachusetts, they didn't hear about it either. And of course, it would be unreasonable for the university to contact everyone that could possibly want to apply for this application.
Somebody in Vietnam, I take it, heard of it because 2 of the fellows were living in Vietnam, correct?
Exactly. And the university...
Not discrimination.
Right.
That's just that its press release didn't work and may have been sent out in violation of some technical rules and that kind of stuff.
Well, paragraph 40, the defendants, through their officers' agents, deliberately chose not to advertise to the Vietnamese American community, both in Boston and in the United States, the availability and requirements of the program until it was too late. We take that as true as well?
Well, Justice Cordy, what is the factual basis of the complaint to support that? The only basis is that
Well, the basis is that you committed to advertise in all of these Vietnamese publications and through all these Vietnamese community media outlets, and it is alleged that you failed to do any of that.
Well, it's alleged that they did at least two Vietnamese community trade publications, correct?
Well, failed to do any of what you promised to do in your program.
That all may not be true, but we're working under the 12b6 standard here. We take it as true.
take it as true, but you also, there also is the important doctrine that the plaintiffs can plead themselves out of a complaint as well that is raised in the case that my sister cites, the Sparrow case. And they have cited many facts in here that plead themselves out. The fact that they had, that there was, the university did do a lot to actually advertise this, and that their claim is really only based on the anti-communist sentiment that they feel the university had, and they can't prove that. I mean, there is no way to make that claim, and that claim is not a viable claim in and of itself.
Is there a claim here that the pro-communists got notice of the advertisement before anti-communist anti-communists received it?
No, there is no allegation of that. The only allegation,
It was late.
well, they're saying it was late, but they're saying they didn't see it until it was late. I mean, something could have been hung up on the board of the Vietnamese Community Center, and the plaintiff just didn't walk in there and see it, or the leader didn't decide to give it to him until a few months after this program closed.
Thank you, Mr. Joyce.
Thank you, Card.